It being 10 o'clock, I'm going to open the public hearing for criminal justice today. I would ask that you rise and join us in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This time, we're going to open the public hearing on HB 89, and we're going to have Representative Muse introduce the bill.
Thank you, Mr. Chair. My name is Representative David Muse. I represent Portsmouth, Newington, and Newcastle. We have been in this place before with this bill, as the chair knows, and those of us who've served over the last couple of terms. And I believe we're in a good place now. One of the things that our assistant Brad Greenland did was he research some of the history of the bill to provide to some of the new members. One of the things that you'll see is in the last session of the legislature, we sent this bill to interim study. And the outcome of the interim study session was that we did recommend it for legislation, which is why the primary reason why this bill is back. But the overwhelming and I think the driving reason why this bill is back is to really do what we can as a criminal justice and public safety committee to when we are aware of incidents where justice hasn't been carried forth effectively, and also where there have been injustices. A lot of times we're not necessarily in a position to correct that. This time, though, we are. This bill specifically would grant posthumous exoneration and annulment in a couple of cases where, over time, the injustice of those convictions has become more and more apparent. So one of these folks, Eunice Goody Cole of Hampton, New Hampshire, was the only person in New Hampshire ever convicted of witchcraft. One of the things that you can see if you actually Google information on Goody Cole was she led a pretty tortured existence. She probably wasn't a very nice person. Her neighbors did not like her. But unfortunately, at the time, dislike for a person could easily turn into accusations of witchcraft, and there was a hysteria that went on at the time. And at the time, the law supported convictions like that. She spent a pretty good chunk of the last 25 years of her life in prison, much of that time at the expense of the people of Hampton, New Hampshire. Those people in Hampton, New Hampshire, or their descendants in 1938, actually formed a group called the Goody Cole Society. And essentially what they did was they basically forgave her crimes. Unfortunately, they didn't have the power to forgive and annul the crimes that she was accused of. We do have that. We are a state where witchcraft is no longer a crime. The other case is the case of Willard Uphose, and I have other folks here who are going to give testimony about this. But he was the head of the World Fellowship Center, and essentially, to make a long story short, an overzealous New Hampshire prosecutor during the Red Scare of the 1950s held Mr. Uphouse in contempt, brought him up on contempt charges for not revealing a list of members and attendees to programs at the World Fellowship Center. Which is primarily an organization that's about nature and spirituality, and we have the former head of it here today to testify on that as well. The the upshot of this of a lot of this is there are periods when there are injustice in our past, and in our current law really doesn't allow a good mechanism for us to address this. So one of the things that's been brought up in the past is, well, gee, why can't the governor just pardon these people? And the reason the governor can't just pardon these people is that the way that our law works now is that the governor can only pardon people who are alive, which is why we're talking about annulments and exonerations. So to essentially sum up, one of the things that we have within our power to do today is to correct an injustice that was done, a great injustice that was actually done to two people who, you know, who didn't deserve it, who may have had issues in other areas, but this is not the way our justice systems should work. And one of the things that our justice system should do when we don't have the power to actually go back and fix things is to make an admission that sometimes we make the wrong decision, and to do what we can to correct the record. So that's really why we're here today. One of the other things that I would like to do with the chair's indulgence is to read testimony that was sent to us by Arnie Alpert, who was not able to make it. Arnie testified at hearings both times on the previous bills. He is out of town and unable to join us in person today. So with the chair's indulgence, I would read that. I would also like to let the chair know that this testimony was also sent in email to the committee. So if you decide in the interest of time that that would work better, that's fine as well.
You can go ahead and read it into the record.
Thank you. And if anybody has any questions about the bill, the legislation, I think we have folks who are maybe better equipped to tell the story and to relate the history of what actually happened during these events than me, but I would be more than happy to answer your questions. Yes.
Assuming this is a terrific bill, correcting an injustice, I have two questions. First, why can't the governor pardon someone who is not living? The second question is, does the legislature really have this authority? There are questions.
Our law currently, as I read it, and I'm not a lawyer, but my examination of the statute, the pardon statute really only does apply to people who are living, and these two folks obviously aren't living anymore. As to whether or not we have the ability to exonerate and annul convictions, we do, and in the last session of the legislature, we actually did that in HB 2 when we annulled the convictions of the folks who violated COVID orders at the time. So I don't think it's a power that we use a lot in the legislature, and I think we're very careful about how we use it. But it is something that there is precedent for. You're welcome.
Just in case anyone else is going to ask, I am going to be soliciting an opinion from the Attorney General's office and possibly the New Hampshire Supreme Court. I personally actually wrote the majority report recommending this for future legislation, and I still support the idea behind it. I just want to make sure it's constitutionally sound.
And I do know that in the past there has been some confusion over where Goody Cole in particular was convicted. She was convicted in a court in Massachusetts. At the time, the state of New Hampshire and the state of Massachusetts actually didn't exist. What existed back in her time in the 1650s was the province of New Hampshire. And essentially New Hampshire was just sort of a series of land grants stitched together without any real type of judicial system. So at the time, we relied on courts down in Massachusetts. She actually served most of her jail time down in Boston. Um, but she was a citizen of Hampton, New Hampshire, which is part of New Hampshire now. So there are some gray areas, admittedly, but there are always gray areas in the law, and this may be an opportunity just to correct something that I think a lot of people over many years have been trying to correct.
Representative Salig.
Thank you, Mr. Chair. Representative, I'm curious, in looking at the history of the bill, there are several references that the language needed to be clarified from the initial version. I'm just wondering if there are differences in this language than previous versions.
I think it's less the language issue and more the issue that the chair raises. So there is an issue, ultimately whether we have the authority to actually exonerate and pardon somebody who may not have been, technically, who actually may have been convicted in a court in another state. Even though at the time we were basically in the same judicial region, I guess you might call it. So
Okay, you can go ahead and read that now that you wanted to read. You wanted to read that testimony?
would you like, I can do that, yes?
Yeah, go ahead.
So again, this testimony is from Arnie Alpert. I regret that I'm unable to be with you in person today to testify in support of HB 89 relative to posthumous exonerations and annulments, but I'm happy to respond by email to any questions you may have. In 1951, the General Court adopted the Subversive Activities Act, which defined and criminalized being a subversive. 2 years later, the Attorney General, Louis Wyman, launched a wide-ranging investigation to find out where any subversives might be lurking. Wyman looked high and he looked low. Among the places he looked were at UNH and Dartmouth faculty. He interviewed 130 witnesses under oath and even more on an informal basis. Among those he subpoenaed for deposition was Dr. Willard Uphouse, who had recently been appointed executive director of the World Fellowship Center, a summer retreat near Mount Chocorua in Albany, New Hampshire. Dr. Uphouse went to Wyman's office at the State House and brought him information about World Fellowship. When asked, he was willing to provide the Attorney General with names of staff, records for which the state are, and with names of staff and also for records for which the state already had access. He was also willing to provide the names of people who had been speakers of the center and even invited Wyman to be a speaker. But Dr. Uphouse balked when Attorney General Wyman demanded the center's guest list, which he knew would subject people to further investigation. A Superior Court judge ruled Dr. Uphouse in contempt, prompting an appeal that went all the way up to the United States Supreme Court. When the Supreme Court ruled 6 years later, after the investigation began on the side of the state, and Dr. Uphouse still refused to violate the privacy of World Fellowship guests, the state sent the now elderly Dr. Uphouse to the Merrimack County House of Corrections, where he sat for a year. During the course of the year, the Uphouse case became a matter of international controversy and frankly a source of embarrassment to the state. 2 points that I want to emphasize. First, after an investigation that he claimed took 2.5 man years, Louis Wyman never charged anyone in New Hampshire with the crime of being a subversive. Second, looking back with more than 60 years of hindsight, we should see the episode as an example of what happens when political passions overcome good judgment. We can also see Dr. Willard Uphouse as a champion for the rights of conscience and the protection of privacy from state overreach. Please recommend HB 89 ought to pass. Arnie Alpert, 1 Mudgett Hill Road, Canterbury, New Hampshire.
Thank you. There being no further questions, thank you. Who's next?
Thank you.
The chair calls Andy Davis.
Thank you. Good morning. It's a pleasure to be here. Thanks for hearing my testimony. I'm also coming out in favor of this bill. I'll try not to go over the same territory that David and Arnie covered. My name's Andy Davis. I, until about a year ago, for 21 years, was the co-director of the World Fellowship Center, the second director after Willard Uphouse, who we're referring to today. World Fellowship was founded in 1941 by Charles and Eugenia Weller, who at that point were in their 70s. They were social activists and reformers who began in Chicago in the first Gilded Age in the 1890s. But by 1953, the Wellers were in their 80s and they were ready to retire from what was in essence their retirement job. So they cast about and they ended up hiring much younger directors, people who were about my age now, Willard and Ola Uphouse. And by the time Willard came to World Fellowship, he had already seen many lives and careers destroyed by McCarthyism. He had suffered the effects itself. Two organizations that he had been a part of, the National Religion and Labor Foundation and the American Peace Crusade, had been ripped apart by internal divisions or disbanded because of the climate of fear that was generated during that time. So at the end of their first summer as directors, Willard and Ola were closing down World Fellowship for the winter. And Willard took a break to go into Conway and run some errands. And he picked up a copy of the Union Leader and his attention was caught by the main headline that said, "Pro-Red takes over New Hampshire Fellowship Group." And of course, the pro-red that was being referred to was himself. He read further to discover the news that he supposedly supported the Communist Party and was harboring members of subversive organizations. That was news to himself. And in a sidebar on the front page, the Attorney General, Louis Wyman, pledged to get down to what was going on at the World Fellowship Center. So this began 7 years of interrogations and court appearances that went through the New Hampshire Superior Court, in which, as stated, he was convicted of contempt for refusing to expose guests of his center to the sort of scrutiny and ordeal that he was going through. And the case went all the way to the U.S. Supreme Court. I'm not sure that was mentioned already, but on November 14th, 1958, the U.S. Supreme Court ruled 5-4 that the public interest outweighed Uphouse's private rights. Given the power granted Wyman by the legislature, the Attorney General could force Uphouse to produce the guest list or prosecute him. Justice William Brennan wrote the dissent, in which he was joined by the Chief Justice and Justices Black and Douglas. He argued that the state had not proved a sufficient interest to justify counterbalancing the interest of privacy as it relates to freedom of speech and assembly. So as Arnie mentioned, the Willard Uphouse case became a cause célèbre. The day that he was led away to jail, 200 supporters were on hand to sing "America, My Country 'Tis of Thee" and "A Mighty Fortress is Our God," which was Willard's favorite hymn. And hundreds of college students around New England demonstrated for his release. And on his 70th birthday, which he celebrated in the Boscawen jail, he received 720 cards from around the country. while incarcerated, Uphouse wrote his autobiography under a painting of Mount Chocorua. And in an effort to be brief, I'll just, it might interest you to know that Willard Uphouse was included on the Concord Monitor list of the 100 most influential people in New Hampshire during the 20th century. And in case you're wondering, Louis Wyman didn't make the list. Another person on the list was Judge Hugh Bounds of Laconia, who served on the New Hampshire Superior Court, U.S. District Court, and the U.S. Court of Appeals in the First Circuit. Earlier in his career, he had been a defense attorney in Willard Uphouse's case. When he died in December of 2003, at his memorial service in the federal courthouse here in Concord, he was eulogized by his friend Justice David Souter, who, taking stock of his long career, specifically referenced Bounds' spirited defense of Willard Uphouse. Souter said that what stood out was Bounds' argument that the state had not a scrap of evidence to so much as suggest Uphouse engaged in subversion. Bounds, Souter said, was facing, quote, facing realities that the powers that be did not want to face and did not want others to face. It was as if he knew, Souter continued, that human beings do not so much avoid responsibility as evade it, and we evade what we do not want to see. Bounds, he said, had the courage to see and to face the truth. So my hope today is that you would look at the choice your legislative forebears made in 1951, see how that choice affected individual human beings, and rectify their mistake. In a day characterized by the politics of division, this is a moment to unite with people of conscience across boundaries of space and time. I'd like to end on a brief personal note. Rennie Cushing was a dear friend of mine, and 3 weeks before he died, I visited him at his home in Hampton, where at that point he was on a bed in front of the bay window looking out on the street on Winnicott Road. And that day, being able to see this bill through. So, of course, I said, Rennie, you have other things to worry about right now. We'll take it from here. So I thank you for your kind attention, and I thank you for seriously considering this bill.
Thank you. Are there any other people wishing to testify on this bill? Seeing none, I'm now going to close the public hearing on HB 89. The committee will be in recess until 10:45. It being 10:45, I'm going to open the public hearing on HB 97 FN and ask Representative Rhodes to introduce her bill.
Thank you. Good morning, Chairman Roy, honorable representatives. For the record, I'm Representative Jennifer Rhodes. I represent Cheshire County District 17, which is Winchester, Richmond, Swansea, Troy, and Fitzwilliam. I'm here this morning to introduce House Bill 97, which will establish an additional penalty for a violation of privacy. This legislation is truly a bipartisan effort of state representatives and senators to address inconsistencies in the law when it comes to adequately protecting individuals against sexual exploitation, especially when it comes to repeat offenses. Last year, we had a bill that was in front of us in the Criminal Justice Committee that was to establish a study committee, and I had asked a question during the testimony of that, and basically, for my own question, I realized just how serious this really is. And over the summer, I reached out to the coalition to work with them to make this bill become a reality. HB 97 is not creating a new law. It is specifically addressing the unlawful and non-consensual violation of someone's privacy for sexual arousal or gratification. The impact of these crimes can be debilitating and demoralizing for the victims, and they have long-term, very real, very psychological and emotional consequences. Victims may suffer from extreme depression, isolation, unemployment, rising medical costs, and homelessness, just to name a few, none of which are any fault of their own. What's worse is often these crimes can become extremely dangerous over time if they're not stopped. Even more concerning is these crimes also can be signs of lethal intent if not taken seriously. It is time that we amend the statute to ensure that we are protecting the victims against being abused over and over again. There are several individuals that are in the room today that are going to testify on behalf of this bill. They have the very real examples of where this law could have helped the victims, and they also will be able to explain how the implementation will work with the other law. So I would respectfully ask that you ask the questions for the professionals that are behind me this morning. Please consider passing this bill so we are better able to support the victims, their families, and all of our communities.
Thank you, Representative. The chair calls Pamela Kalig.
Good morning, Mr. Chair and members of the committee. My name is Pamela Keilig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As some of you know, the coalition is the umbrella organization for our 12 community-based crisis centers that provide free and confidential services to nearly 15,000 survivors of sexual and domestic violence annually. I'm here to speak in support of HB 97, legislation that will bring our state's violation of privacy statute, RSA 6449, into alignment with other similar laws relative to sexual violence and exploitation, as the good representative said. And thank you so much for the opportunity to speak today. I think first and foremost, I just wanted to provide a brief overview of the legislation and why it's important. RSA 6449 is one of several statutes that seek to address crimes relating to sexual violence and abuse. And this bill specifically speaks to paragraph 3A of the statute that involves videoing and observing for the purpose of sexual gratification and arousal. And so those, there's two statutes that I just wanted to briefly highlight, and I have materials that I'll hand out to the committee after my testimony. So RSA 645-1, relative to lewdness and indecent exposure, and RSA 652, obscene matter, already have specific provisions that address cases where offenders commit the same crime again and again. So this statute is just looking across the board when we're treating these crimes and looking at the specific systemic pattern of behavior that comes with sexual violence, and making sure that we're addressing the severity of not only when this crime happens once, but when it happens again. And so I think just it's really important to highlight that although it may seem like it's just about a video recording, this can actually escalate into physical violence and lead to significant harm on the victim, as well as making the general family involved or community not feeling safe. And then I guess I just wanted to also highlight that violations of privacy can be co-occurring with acts of stalking, sexual assault, domestic violence, and child abuse. And offenders in these cases are seeking to undermine a victim's sense of safety and control. And I'm sure you're going to hear from other folks in the room today just to, like what we're really talking about in terms of the types of behavior involved, of progressively escalating from, you know, looking into a window to eventually breaking into a house and then potentially even committing sexual assault. So the goal of this legislation, not only to bring it into alignment with other similar statutes, is to really ensure that the appropriate interventions come in place to not only limit the harm to the victim, but also ensure that sex offenders and individuals perpetuating these crimes are getting the support they need to stop this behavior. And I guess just to kind of another part of the handouts that I'm going to be giving you today highlight a few case studies that kind of illustrate how this type of behavior can happen over and over again. And we have countless situations in our state where individuals have committed acts under RSA 6449 and later went on to committing those to physically assault their victim. So I just wanted to highlight that this is something we're seeing and something that we really want to address. So I would just like to conclude by just asking you all to consider supporting HB 97, and I'd be more than happy to answer any questions.
I have a question. Do you have any information on other states that have passed similar legislation?
That's a great question. I'd be happy to look into that for you, but I don't know off the top of my head.
Thank you. Representative Bolden, go ahead.
Thank you. Thanks for taking my question. I recall that there was someone who was arrested for recording people in restrooms in the Manchester Mall. Can you speak to how this would affect that?
Yeah, and I know that there's a prosecutor in the room that might be able to speak more to the technical aspects of that, but I think, and I might know actually exactly what case you're referring to, but I think when we see cases like that, oftentimes it's not just one restroom, and so oftentimes there are many victims spanning over multiple incidences, and so when you have, right now it's I think a misdemeanor level offense. And so, but there's no way to address a subsequent offense. So the same person might be convicted for a violation of privacy the first time, and then they could be convicted again, and then again and again, but the penalty is not raising. So this bill specifically is acknowledging when it happens 2 or more times to really ensure that it's being treated seriously, and it's acknowledged that this is a really impacts victims who are experiencing this type of violation of privacy.
Representative Newell.
That example just kind of brings up a question for me, kind of nitpicky, but does it, you know, when we're talking about multiple cases, are we talking about multiple people? For example, in that situation, they may have viewed many people. It's one incident. They would probably go to court for, you know, one overall incident, but it could be multiple people. So when we're saying second and third offense and things like that, are we talking about the person or the incident?
The incident.
Okay, thank you.
Thank you.
Thank you all very much.
The chair calls Dr. Scott Hampton.
I am trainable, a little bit slow, but I'm trainable. My name is Dr. Scott Hampton. I'm the director of Ending the Violence, which is an organization in Dover where we work with perpetrators of domestic and sexual violence and also offer training and consultation for other professionals in the field. Over the last 32 years, I've worked with thousands of perpetrators and victims of interpersonal violence, and my testimony today is going to be based on what I've learned from that experience. I am here today in support of House Bill 97, and I do appreciate the opportunity to share some of my views about that. The focus of my testimony is going to be on the deterrent effect that I believe the proposed legislation would have on offenders. To do that, I'm going to explain the forces that have not only allowed, but actually encouraged offenders to violate privacy en route to sometimes committing even more serious offenses than that. To begin, I just want to talk about sexual violence. Point out that sexual violence is different from other forms of assaultive behavior because it's not inherently violent. It's contextual. And what I mean by that is that, for example, sexual intercourse, fondling, voyeurism may or may not be a crime, all depending on whether or not there was fully informed consent. What that does is it creates some ambiguity, which makes it difficult for us to sometimes determine whether or not a sex crime has been committed. But even more importantly, it actually makes it easy for offenders to delude themselves into thinking that they haven't crossed some significant line, when in fact they've actually caused pretty significant harm. So where do they learn this? Where do they learn that it's okay actually to invade someone else's privacy? Well, 2 words: sex education. Bear with me for a moment. I may not be going the direction you think I'm going. The most popular sex education program in the world enthusiastically endorses voyeurism. Unfortunately, it teaches people sometimes as young as 10 years old, sometimes even younger, that it's okay not just to look at people who are naked, but actually watch them while they're engaged in what probably should be a private sexual encounter with another person. It also teaches them, I do see some confused looks, I'm going to take care of that in a moment. It also teaches them that it's okay during sexual behavior to slap, strangle, degrade, humiliate, and commit other acts of violence during that sexual act. So what do we call this ubiquitous sexual education program? Pornography. Multi-billion-dollar business that unfortunately is the training ground for many sex offenders. Even before sex offenders have a chance to groom their own victims, the institution of pornography has groomed many of these offenders to commit their crimes by sending the message that it's okay to seek sexual and other forms of gratification at the expense of another human being. So why is this so important? Let me just give you, like I said, I've worked with a lot of offenders. Let me just give you one example. It's a generic example of one person's progression from voyeuristic activities to something more severe. So this guy walks out of his house, walks down the street, notices it's nighttime, so it's dark outside. He notices that there's a light on in a woman's bedroom. He's standing on the sidewalk, looks in, sees her getting undressed, stands on the sidewalk, watches her. Okay. The next time he comes out, same street, same situation. This time he walks halfway onto her yard, wants to get a closer look, watches, goes on home. Next time he walks up to the window. The next time he waits until she's asleep, walks onto, this is how he's describing to me in group, how his progression worked, walks onto her front porch and just stands there for a moment, seeing what it feels like to be close to her front door. Next time he puts his hand on the door handle, doesn't try to open it, but imagines walking inside the house. Next time he opens the door, closes it. This progresses, walks in the house, walks down the hallway, goes to the end of her bedroom, goes to the foot of her bed. The final night, he violently rapes her. So it began as a gateway offense, progressed unabatedly to a violent sexual act. There was no message along the way. There was nothing that said, you have a reason to stop. Well, we have an opportunity today to give him a reason to stop. Voyeurism is a gateway offense. So just like someone who's a drug addict, they start with cigarettes and beer and marijuana before they progress to cocaine and heroin. Sex offenders do the same thing. They always describe to me, say, well, I start off with a low contact, low risk offense like voyeurism before I progress into the more severe, even worse offenses like sexual assault and rape. They're not satisfied by pornography. They want to be part of the action. So like that case study I just mentioned, they engage what we call successive approximations. And if along the way, no one is objecting, no one is saying this is not okay, no one says you have to stop, they will continue to progress. The guys in my group, this is what I want to leave you with. The men that I've worked with in my group, and I've worked with some women as well, describe this gradual escalation from this low risk, low violence onward. Some had dozens of victims. Some had committed hundreds of sex crimes before there was any meaningful consequence to them. They all told me I had no intention of stopping until I was caught, until someone said that this was. None of them, and this is the important point for today, I think, none of them that I can remember over the 32 years ever told me that they got that firm message because they merely violated someone's privacy. It was always something more severe than that before the system said, wow, this is really not okay. You need to stop doing that. So victims are waiting for us to send that message. Offenders are waiting for us to send that message. I think we all are waiting for that message to be sent. And I think you have an opportunity today to deliver that message. So thank you for listening to me and considering my request that you support House Bill 97. I'd be glad to answer any questions.
Representative Bolden?
Thank you. Thanks for taking my question. I just wanted to clarify where you work.
In Dover, well, actually I work in Dover and I also work in Texas, but that's not relevant today. I work in two places, Ending the Violence, which is where we work with offenders. I also am the coordinator for the Stratford County Supervised Visitation Center. So I work with the offenders, the victims, and the children during a reunification process.
Follow up.
Thank you. Thanks for taking another question. So that was what I was trying to understand is the stories that you shared are people that are local to New Hampshire?
Yes, and this one example was in our sex offender treatment program probably 10 years ago or so. But I've heard variations on the theme, and a lot of this where what we do in a treatment program is we go through what are called offense cycles. And so what we try to do is we map out the progression of what they did, how they make decisions, what were you thinking, feeling, and doing at various stages, and how does that progress over time? And this is a generic but a very common presentation that I would hear.
Representative Salig.
Good morning. Thank you for
Morning.
your testimony. I live in Durham, and you may be familiar. We had a person who was nicknamed Jack the Snipper,
Yes.
who was going into people's homes, for those of you who are not familiar, and breaking into their spaces, and he, while they slept, literally cutting off their underwear and taking it as a trophy.
Right.
How would this legislation be likely to stop his behavior or to ensure that he didn't just continue to be essentially caught and released like a fish?
Well, catch and release is a really good analogy for it, because I hear that conversation a lot from the guys in my group. I've had people who've come to my program who've been convicted on misdemeanors, and sometimes they blow off group. They don't really care what the probation officer's telling them to do, whatever. And I've heard them say, well, my thing, they do constant comparisons with each other. So they'll say things like, well, I only got convicted of misdemeanor. That person got convicted of a felony. And, so what I did really wasn't all that bad. They're constantly doing these comparisons. So I think when we upgrade this, the same way when we upgraded the strangulation statute after the Missy Charbonneau case, and that went from a misdemeanor to a Class B felony, the conversations that I heard amongst the people in my group about, wow, I never thought it was that bad. And just the fact that it was moved up to a felony was a tap on the shoulder, and they're starting to ask me questions. Why do they think it's that bad? I thought it was no big deal before. So I'm imagining there's going to be the same kind of impact that we had when we upgraded strangulation, just by going from misdemeanor to felony.
Representative Sitek.
This may be a question for the chair. Are we going to hear from someone from the judiciary? The reason I'm asking is that we're trivializing a misdemeanor. Where are the judges on this? The misdemeanor carries a year in jail. I mean, that's not trivial. And I'm wondering whether that's ever actually done.
As far as I know, no one from judiciary is going to be taking a position on this. We could solicit one, though.
May I comment on it? So the one thing I would say is that I completely agree with you. If I think about where I am in life right now, and if someone said, how about we change your life and convict you of a misdemeanor, that's going to sting. The baseline for a lot of people in my program is different. For some of them, a misdemeanor is like having a bad cold and something that they can just take in stride. So for you and me, that would be a significant change. For some of them, not so much so.
Representative Guthrie.
Just curious, your program, is it for changing behaviors? Trying to understand your program when it comes to the person that's assaulted someone.
Good question. Changing behavior, yes. Changing the attitudes and belief systems that support that behavior, even more foundational. So, we can say, well, you can't do X, Y, and Z, but if they don't understand why X, Y, and Z are a problem or the bigger issue, then that change isn't going to last very long. So it's both attitudes and behaviors that feed into the actual crimes they committed.
So what would you say your success rate is at this time? And how long have you been in this process?
One of the challenges with success is that the most common way of measuring that is what we call recidivism. There's a problem with that statistic, even though it's a favorite amongst researchers. Recidivism doesn't tell you whether someone's recommitted a crime. Recidivism tells you whether someone was caught. So my answer to how successful we are, do we have people who have chosen not to recommit those crimes? Yeah. What we try to do is we say, how can you go about getting your needs met in a way that don't cause problems for you or for someone else? So we give them alternatives. Are there ways to engage in a healthy relationship that don't involve invading someone's privacy, for instance? So we do have success with that. It's hard to measure because we have some people who never get rearrested, but find new ways of avoiding accountability. And so we don't have solid data for that, I'm afraid to say. But what I would say is that our success isn't based on what happens in my program solely. It's based on the community response. So when an entire community takes an issue seriously, we have much better success. It was like someone said, offender programs are most effective in communities that don't need them, which is kind of a weird statement if you think about it. But it's true. It says if we all take it seriously, then that's where the change really happens. The program itself, by itself, won't do it. Legislation, my work, law enforcement, how much we follow through is important.
And I believe the witness testified 32 years. Representative Sitek.
Well, this is actually slightly off topic. I'll make it quick. You're a doctor. I believe what you said, you can change behavior. Can you change the foundational attitude of someone who is given to this inclination? Can that ever change?
It's probably a matter of degree, and there certainly are individual differences. There are basically three groups of people who commit sex offenses. There's one group of people who absolutely want to do harm. These are the more sociopathic, psychopathic ones. Change with them is very difficult and unlikely, and the best we can do is do a tremendous amount of monitoring and give them fewer options to act out. There's the ones who want to cause harm. There are ones on the other end of the spectrum who really don't want to cause harm, but they're really lacking information, so they really don't understand boundaries very well. And maybe they grew up in an environment where boundaries didn't exist or they were just really distorted. Those people, we can make a tremendous amount of change. And then there's a group in the middle where they don't want to cause harm, but they don't really care if they do. A lot of people who commit what we call date rapes and stuff are sort of those, like, I'm going to go out and, buyer beware kind of thing. And they're kind of in the middle. So we can have a significant impact on them when we offer alternatives to them, but there's some people that are untouchable.
Representative Newell.
Thank you. Thank you for taking my question.
Sure.
Is your program a mandated, a part of a recovery scheme or something like that, or is it voluntary?
So I'm going to change the question a little bit. Most of the people coming to our program are court ordered. We do get some people who are otherwise referred. So in other words, when we talk about voluntary, that makes it sound like they just on their own want to do it. We have people who have other reasons, like, oh, my partner said if I don't come to your program, he's going to leave me. well, is that voluntary? It's not court ordered, but yeah, you sort of see where I'm going with that. We used to do just court mandate, but what's interesting is that we've had people talking with other people. I have a guy in my program. He talks to someone that he goes to work with, and I just had someone about 3 months ago who said this. He said, "I've never been arrested for committing this kind of crime. However, I want to keep it that way." And can I be part of the conversation? So I get a phone call saying, I'm not court referred, but I could use some of the stuff you guys talk about. Are your doors open? And I say yes. So I would say we have about 15% of the people in our program that are otherwise referred. The rest are court ordered.
Thank you.
Sure.
There being no further questions, thank you for your testimony.
Thank you for your time.
The chair calls Stephen Enders. You have to pardon me, I don't have my reading glasses today.
I have spares. Good morning, Chairman, members of the committee. My name is Stephen Endres. I'm a prosecutor in the Merrimack County Attorney's Office. I'm an assistant county attorney. I've been a prosecutor for a little over 20 years now. Really what we're talking about here is punishment for a crime, which is really a policy decision for the legislature to make. And certainly Dr. Hampton has given you some reasons to consider that policy. I mean, personally, as a prosecutor, I support the idea of an increased sentence for a second offense. I spoke to County Attorney Halverson earlier today. He also indicated that he supported this legislation. Really, there's a number of statutes in New Hampshire where we already have second or subsequent offenses with increased punishment or increased criminal liability. Indecent exposure has passages for second or subsequent offenses being felonies. Stalking has a provision where a second or subsequent offense can be charged as a felony. Cruelty to animals has felony provisions for subsequent offenses. Even theft in New Hampshire, a third offense, can be charged as a felony regardless of value. And then throughout the motor vehicle code, there's examples where subsequent offenses have higher penalties, such as operating after suspension or driving while intoxicated, for example. To explain a little bit about how it actually works in practice, a person would have to be arrested, charged with a violation of 644-9, and then convicted of that violation, and after conviction commit a subsequent offense for this to be charged as a felony offense. So there were questions about multiple victims, that type of thing. If you did this, if you committed a violation of privacy against 10 people with no prior convictions, all 10 of those would end up being charged as misdemeanors. You'd have to be convicted at least once, and then a subsequent offense could be charged as a felony level offense. But as I said, this is in line with other New Hampshire statutes and certainly is a policy decision for the legislature to make. Happy to answer any questions.
I have a question. Would this legislation, if it were passed and signed into law, would it assist you in obtaining plea bargains and things of that nature?
Absolutely. I think it would assist in working cases out. I think it would also perhaps assist in maybe not having subsequent cases, because as Dr. Hampton said, if you're convicted the first time and you're told, if you do this again, it's a felony, that may deter your behavior. Certainly, as Representative Saitek mentioned before, a misdemeanor is not a trivial offense. An offender can spend up to a year in jail for a misdemeanor level offense. However, our goal isn't always to incarcerate people. In fact, that's not our goal at all. And if I had a person charged with violation of privacy, one of the things I would want is for them to participate in a program like Dr. Hampton offers. So I would probably do a suspended sentence or a proportion of that sentence suspended conditioned on them receiving treatment. I can only hang 12 months over their head in a suspended sentence. If it was a felony level offense, obviously there's a greater ability to incarcerate a person on a felony level offense. There's also collateral consequences of a felony conviction, which we may be able to bargain with to get that person hopefully into treatment and the help that they need.
Thank you. Could you just briefly to the committee explain on first offenses, is there any type of a continuance where there's not a conviction, like a without a finding type of thing where this would not be triggered?
Certainly. There's a range of penalties that we can sort of discuss for first offenses with there's a range of conviction and non-conviction resolutions to criminal cases. We send criminal cases to diversion on a regular basis, where diversion is a program that if you go through a certain program, take classes, maybe perform community service, we would agree not to prosecute you for the crime. There's no set rule that says we can't send a violation of privacy case to diversion. I'd be unlikely to send a violation of privacy case to diversion because of the nature of the case. So there are absolutely non-conviction resolutions that could occur. There are conviction resolutions that could occur. And as we had said, you can get anything from no time in the House of Corrections up to 12 months stand committed. There can be fines up to $2,000. We could have follow-up treatment. There's possibilities of a conditional discharge on a misdemeanor case where after you fulfill the conditions of your sentence, the conviction would essentially be vacated. So there's certainly a variety of tools that wouldn't be unique to this statute, but in general exist for all misdemeanor and felony prosecution.
Thank you. Representative Bolden.
Thank you. Thanks for taking my question. I appreciate hearing that you believe that you could potentially, if this were to pass, arrange for agreements where someone would enter treatment under a suspended sentence and I assume good behavior. Do you see that being more common? I'm asking because I can see that the benefits of maybe not having people in the jails as much.
Absolutely. It says in the New Hampshire Constitution that the purpose of the criminal justice system is essentially rehabilitation. So rehabilitation is something that whenever we're crafting a sentence is something that we're looking at. So in almost every offer I've ever made as a prosecutor, there's been some degree of rehabilitation within that offer. Jail is even, in my opinion, partially a form of rehabilitation because it may cause you to look at what you've done and think perhaps you don't want to do that in the future. So I know that whenever I've had violation of privacy cases, there's always been a sex offender treatment aspect to those sentences.
Representative Salig.
Thank you so much. You heard my question to Dr. Hampton, I believe, about Mr. Snipper in my
Yes.
community. I'm curious how your perspective of how this might potentially stop someone like him from perpetuating his behaviors, and also what you see as the potential downfalls of this type of legislation.
I'm not completely familiar with the Snipper case. I know I heard about it on the news. If that individual didn't have a prior conviction, this legislation wouldn't affect him at all. This would only affect subsequent convictions. My recollection from that case, as you indicated, is that he was actually entering people's homes. And I would assume that instead of being charged with violation of privacy, that he would have been charged with burglary, which is a felony level offense, for breaking and entering into the dwelling of another with the intent to commit a crime therein, with the crime either being theft of the underwear or the crime being violation of privacy. So I think that there are felony level statutes that sort of address some of this behavior, especially when you're entering people's houses. I would expect that you would be charged with burglary rather than violation of privacy. I don't know if that
Representative Newell.
answers your question.
Thank you, Mr. Chair. That question kind of brought up another question for me, which is if there is some type of diversion or program, when you say non-conviction options, what we're talking about here is based on incidences, how many incidences. So it kind of builds on itself, right?
Right.
And what I'm curious about is if it's a non-conviction option, which I think could be a good option, but does that count towards this where a second or third offense would carry a different weight?
It would not count toward this. So
Okay.
you would need a conviction for a subsequent offense to be a felony. So if a first offense was sent to diversion for whatever reason, I don't want to say that would end up being a freebie for the purposes of this statute, but it wouldn't count as a prior conviction.
Okay, thank you.
There being no further questions, thank you for your testimony.
Thank you.
Is there anyone else in the audience wishing to testify on this bill today? There being none, I'm going to go ahead and close the public hearing on HB 97 FN, and the committee will be in recess until 11:45.
We were expecting more.
6, I'm going to go ahead and open the public hearing on HB 107 FN, and I'm going to turn chairing this hearing over to the vice chair because I'm a co-sponsor. Here you go. Careful.
Thank you, Mr. Chairman. Representative Verville, here to introduce the bill.
This one, bang.
Thank you, Madam Chair, honorable members of the committee. It's like deja vu all over again. So this is the third time this bill wends its way through the House. The first time it passed the House and died in a Senate omnibus bill. Last term, it passed the House on a very nice bipartisan vote and went over to the Senate where they decided interim study. So maybe the third time's a charm. I don't know. So this bill was requested from a constituent of mine in Deerfield, and there's some papers working around for 2 news stories from the genesis of this bill. I emailed them to you, so you don't need the paper copy if you don't want it. You heard a lot of testimony this morning that carries over to this bill very, very nicely. And so what this bill aims to do is to prevent registered sex offenders from hiring, managing, and supervising minors. Doesn't prevent them working at a business that has minors present. It just prevents them from being placed in a managing or supervisory role of minors and working directly with them. This serves 2 purposes. One, it protects our minors against being potential prey to registered sex offenders. We heard discussion earlier about recidivism rates on registered sex offenders, and it's, if not the highest, one of the most highest recidivism rates of any crime. We also heard interesting testimony that when we talk about recidivism, we're talking about people that get caught. So the rate is likely much, much higher because not everybody gets caught. And so for that reason, this bill, this change in the law, right? This is not new law. This is to close a loophole in existing RSA that will protect the registered sex offender. So if it prohibits the registered sex offender from doing something, how does it protect them? It protects them because it prevents them being placed into a position where to recommit the crime or a similar crime is not presented to them. So it prevents putting them where they're likely to reoffend. Last term, and I know it's a new term and it's a new House. I get all that. Last term, we had a subcommittee. We did great work. The language that's in front of you came out of that subcommittee. This is language that was approved by state police, prosecutor's office, victims advocates, as well as offender advocates, right? Everybody has an advocate and everybody should have an advocate. And we all came around the table Republicans, Democrats, victims, people that are trying to fix their lives from mistakes they've made in the past. And we all agreed that this language was good language, that this language closes the loophole that currently exists in our law that allows situations like you see going around to occur. So the first was a landscaper from my community, registered sex offender, was hiring and directly managing, directly supervising minors. That puts both the minor and the offender in a potentially very dangerous position. And the intent of the law was to disallow that, but the law, by interpretation by the courts, does not prevent it. And so the law needs to be changed so it does. The second incident was a carnival ride operator working for the vendor that provided rides at the Deerfield Fair. That operator was a registered sex offender, was operating a ride, physically assisting children both on and off the ride, checking restraints, checking buckles, so very close proximity. We all know that minor children have favorite rides and therefore are likely to loop through and ride that ride many times, providing many opportunities for contact that this law was designed to prevent. But as it was originally written, in the eyes of the court, does not. And so this language merely closes an accidental loophole in existing New Hampshire law. I would strongly encourage every member of this committee to vote in favor of this so that we can bring it to the floor of the House, pass it for a third time, and then hopefully get it through the other body. That's the intent of the law. This language has been gone over many times, and so that's what we're looking to do here today.
Thank you, Representative. Are there any questions from the committee?
Yes.
Oh, Representative Muse?
Yes. Does your bill actually include the language that was suggested by Representative Lynn last year in his amendment?
So for those that are new, and for those that have been with us for a while, when this bill came to the floor of the House, Representative Lynn offered a floor amendment. I don't know what his motivation was. He didn't testify in the committee when the bill came before committee. He didn't participate or attend the subcommittee hearings. And he never reached out to myself or any of the co-sponsors on the bill. And so I was a little surprised by the floor amendment. The effect of the floor amendment, in my opinion, would change language to leave the loophole open. So while the language was changed under that floor amendment, it would have left the loophole open. So it sounded nice, but it removed the teeth. And so there was a floor debate on the Lynn amendment, and that floor amendment was resoundingly defeated on the floor of the House. And so, no, this bill does not include the language of the Lynn amendment. Thank you for the question, Representative.
Representative Bolden?
Thank you. Thanks for taking my question. My perception is that there's different levels of being required to register on the sex offender registry. I don't know if that's accurate, but you have in your handouts here Edward Proctor and David Getchell. Were those people convicted of crimes against minors, to your knowledge?
Thank you for the question. I do not know the specifics of the crimes they committed, but they were convicted of sexual crimes and are forced to register. As far as I believe they both were, but I couldn't swear an oath to it. So, if I may, Madam Chairman, I'm not an expert in the registered sex offender database. One of the challenges that we know we face is when we try to get too fine, when we try to put too fine a point on it, when we try to get too granular, the language starts to get difficult and is more open to interpretation. To be quite frank, most of the opposition to closing this loophole is a fear that it will further reduce limited employment opportunities for registered sex offenders. And the original language potentially could have prevented a registered sex offender from becoming a corner store clerk, because kids come in after school, they buy candy, he's the clerk, she's the clerk, they're making the transaction, so they're servicing children, but they're not, right? They're not in a direct supervisory type of role. The business is not to provide services to children, it's to the general public. So those sort of incidental type encounters, I agree, we don't want to ban them. And it was argued that, well, gee whiz, you know, you could have a landscaping crew of 3 people, and so perhaps one of them's a registered sex offender, perhaps one's actually the supervisor, and then the third employee is a minor. So would that be okay? Yes. Until the supervising manager has to go somewhere else, until they're called off that location, and now the minor child is left behind on a job site with the registered sex offender. At that point, it becomes a problem. So if the trio has to be broken apart, then the registered sex offender has to be the third person out. Right? The minor has to go with the non-registered sex offender so that they're not left alone. That's the thing. We don't want them alone with children, because that's when you have these opportunities. Thank you, Madam Chair.
Representative Newell.
Thank you. Thank you, and thank you for taking my question. I'm curious, you know, just looking through this, one of the example cases that was handed out here, and it says Edward Proctor of Deerfield was previously convicted of a sexual assault, and at the time of his arrest in 2016 was listed on the state's sex offender registry. However, he no longer appears on the list, and that's what I'm saying. Is there a statute of limitations for how long you're on the sex offender list? It seems like these cases are fairly serious. So I'm just shocked to hear that someone would no longer be on the list.
Thank you for the question. So again, I am not an expert on the sex offender registry, and happy not to be quite frank. I don't know the circumstances as to how that person came off the registry. My understanding, and you have to take it with a grain of salt. I am not a lawyer. I don't want to play a lawyer, but my understanding is basically when you're put on the registry, you're essentially put on for life. And there is some debate whether that's appropriate or not appropriate. And if somebody wants to file legislation to address those issues, I wouldn't discourage that from being considered. My guess is there was probably some change in his status. Either there was an appeal and it got overturned, and that allowed for him to come off the registry. I don't know. I don't know the details. You know, once that person's off the registry, then they don't have to worry about any of this, right? It's only when they're on the registry, and they have a duty, they have an obligation to notify potential employers, right? So that nobody is caught in arrears. But look, I won't lie to you. My intention is to protect children, right? my constituent came to me and requested this, and when I looked into it, I said, yeah, this needs to be addressed. And it was upon further review that I realized that this is protecting both sides, right? We are protecting potential victims from being victimized, and we are protecting past offenders from reoffending by not putting them into a position. We're doing both groups a favor. As for the employment opportunities, you know, we are blessed that we live in New Hampshire because we have a very, very resilient job market. We typically have one of the lowest, if not the lowest, unemployment rates in the nation. I'm old enough to have lived through the recession of the 1980s, and we had a lot of economy in a few baskets, and it hit and it hurt. And New Hampshire went to great lengths to diversify our economy so the next downturn didn't take everything down with it. And that's a success story for New Hampshire. And so there are plenty of job opportunities for these people other than directly supervising, directly working with minor children. I don't, and we can all make our own decisions on this for sure, but I don't see this bill, this closing of a loophole, being overly burdensome on anybody. Thank you for the question.
I just would like to take a moment and point out to the committee that there is a statute for registered sex offenders, and my understanding is it depends on the time of the sentencing. Whenever our researcher comes back in, I could ask him to look that up for us, or if somebody has a computer out and would like to, but I do know that the answer to the question's been going around there, that there is a statute for that. Representative Bolden, you have another question?
I was hoping to figure out, and maybe this is something Brad can do, and I could just email Brad and ask him, and I guess he can like send the answer to everyone, but to understand if there's different levels of registering on the sex offender registry, and
Right.
if there's a difference between, is that what you were saying?
Yeah, that's exactly what I was saying.
Okay,
When he comes back
like-
in, I'll ask him.
And if
to-
there's a way to differentiate between sex offenses as it relates to this bill also? Thanks.
Yep. When our researcher returns, I'll certainly ask him to do that and send the information to all the committee, because it seems like a lot of us have the same question. Are there any other questions for the representative? Representative Newman?
I have a question. I don't know if you're aware of, Representative Lind has sent email around that suggested a change to this, and he gave an example about a child that may get director services, which I think would be probably an extreme case, but in Market Basket, where the child might come up and buy something, a minor might do that. And so I read the bill, and it says direct services to minors. And I'm just wondering if that's inclusive or exclusive enough that the language in the bill would not affect that kind of situation.
Thank you for the question, Representative. I appreciate it. We've gone around on this quite a bit, and you know, the prosecutors, the state police, the victims advocates, the offenders advocates were certainly not uncomfortable with this language when we did the subcommittee. I understand that Representative Lynn has that as a concern. I don't. I think the interpretation of direct services is when that is the purpose of the business, is to provide direct services. An example would be a private school. That is a business that provides direct services to minor children. And, you know, that's already prohibited in other parts of statute, right? So I don't believe that if I'm working at a grocery store, I hate to use brand names, right? Because they have competition. So I'm a registered sex offender. I'm working at a grocery store, and I manage the bread aisle. And a child comes down the aisle because the parent sent them off, go get English muffins. And the child is looking and can't find English muffins. Sees me in a store clerk uniform and says, "Excuse me, sir, where can I find the English muffins?" And I say, "The English muffins are there." Right? Did I provide a direct service? Yeah, I gave them location of the English muffins. I'm not in a supervisory role. I'm not in a managerial role over that person as an employee. This is an employee thing. So that's a customer. So I don't think that fits the definition. Now, again, I'm not a lawyer. You know, can somebody drag it out that far? You know, maybe so. And so let the employer decide what position they want that person to have. You know, there's plenty of jobs that aren't customer facing in most of these businesses that these people could fill. So if we're going to err in any direction, I would suggest it's our duty, our responsibility to err on the side of caution instead of erring on the side of some minuscule chance of a what if. I'll flesh it out further if you'll indulge me. So I'm the parent that just sent the child to me to find the English muffins, right? And so how am I going to know that the bread clerk is a registered sex offender and then file some sort of complaint on a one-time interaction like that? I don't believe that's reasonable to think that would occur. In fact, I would go a step further and say I don't have children. And I know I'm a registered sex offender and I see myself working in a store. I could tell the store, you know, that person is on the registered sex offender list and you have them working in a job where they're near children, and you should consider doing some due diligence around that. My gut tells me any employer that was notified of that would take that seriously and take some corrective actions there. It's hypothetical, but you're asking me a hypothetical. So no, I don't. A business providing direct services to minors. A business providing direct services to minors. I don't believe a grocery store provides direct services to minors. I don't believe that the clerk at a local convenience store that is selling items to children before or after school is providing direct services. I mean, you're selling goods, but I don't believe that that's the case.
Follow up, Representative Newman.
I probably should not have mentioned a public business. I probably should have been more generic. I don't have any, I don't oppose anything that you said. I agree with everything that you said about that. It was a hypothetical one and maybe an extreme one. I only asked the question to find out. I'm not a lawyer, just to clarify the language in which your opinion was, and I appreciate your answer. My question is, and this is just because I'm kind of a geeky kind of person, in the law, is there, and maybe someone else can answer this question, in the law, is there, or in New Hampshire law, is there any actual definition in any of the statutes that describes the term provides direct services to minors? And I don't know whether you know that or not, but I'd just be curious. Thank you.
Thank you for the question, Representative. It's actually an excellent question. I do not know where that would be defined in RSA. But again, I will loop back to my position that if we are going to err, we should err on the side of caution, we should err on the side of protecting children, and we should err on the side of preventing opportunities for people to commit again. Thank you.
Representative, just to clarify, you're saying that if a person owns an arcade and a person comes in and applies for a job that is a knowing registered sex offender, that would be a perfect example of a place that sex offender should not be seeking employment?
No, I don't believe that statement as made is correct. So I get, people get mad at me because they say I'm too specific on language. So I own an arcade, registered sex offender comes in, applies for work. Are they prohibited from working there? I would say no, they are not. They should not be managing other employees that are minors under them. If I owned a business like that, because there are already certain prescriptions in law, that would not be a good candidate if my arcade is frequented by children, which we all know they are. So it goes back to the carnival ride operator. Can I work for the carnival ride company? Yes, I can. I can set rides up. I can break rides down. I can clean rides at night. I should not be helping children on and off rides on a repetitive basis. So is there a job at the arcade for a registered sex offender sweeping the floors after the children are gone? Absolutely. Things like that, sure. Any employer that's hiring registered sex offenders that are going to be doing that kind of work, I don't think they would do that. I would think.
That actually did a great job of clarifying that. Thank you very much. Are there any other questions from the yeah.
I would call that last statement a loophole.
Is that a question?
Yeah.
What-
Isn't that a loophole? That, yes, they can come work for that. Supposed to work, sweep the floors, but now they're short one day and he's out on the floor.
The short one day shouldn't be allowed. So it goes back to the landscaper. So I have a registered sex offender that's on a landscaping team. He can't be the manager. He can't be the supervisor of the minor. That's what we're disallowing. And I apologize. Thank you for the question.
Representative Svitek?
I see in the present law, which I think, I see in the present law, not limited to, involving the care, instruction, guidance, the language that's struck out, but not limited to. And it seems to me that the court has tried to balance competing rights here. I don't see why the present law isn't working. Your constituents unhappy, but these aren't egregious examples I'm reading here. It seems like the court has balanced. I don't know if that's quite a question, but what's wrong with the present law?
Thank you, Representative. That is an excellent question, and I apologize if I have not made the answer to that clear. First of all, we're striking out the examples because they're often used to narrow focus, and we don't want to narrow focus. The problem with the current law is it puts minors under direct supervision, under direct management, right? Direct supervision or oversight of minors. You're putting them in close proximity. So you're putting a registered sex offender and a minor together. I used to be a school teacher, and every school teacher job I ever had, and I only had a handful, but I had a handful. Every teaching job I had to pass a criminal background check. Do you know why we have criminal background checks for teachers? I know you do, because I know you're a former educator as well. And I apologize, current educator. We do that because we don't want registered sex offenders or people with bad criminal backgrounds working in schools with children. We do that to protect the children. In that case, we do not do that to protect the person seeking employment. We do it to protect the children. All right? Why do you rob banks? Because that's where the money is. Okay? So this is to protect children beyond the schoolhouse setting. If it's good enough for a public school, it's good enough for children everywhere. I mean, I guess the question is, closing the loophole, what is the damage? What is the damage of closing this loophole? It's a rhetorical question. Answer it your own way in your own head. What's the potential damage if we don't close the loophole? Okay? So most of us are probably parents. And if we're not, I would assume we love and cherish children. What is the damage if we don't close the loophole? That damage, the damage of not closing, the potential damage of not closing the loophole in my opinion, is far greater than any protection or any lack of damage on the other side of the ledger. In my opinion, this is a loophole that needs to be closed. The House has voted in favor of this legislation twice before. First time it died in an omnibus bill. I guess both are correct. Last year, because people are a little nervous, this might be too constricting. And it's my colleague from the House who we've referred to earlier. And it got interim studied in the Senate, and the Senate hasn't done anything. We've passed it twice. We should pass it a third time. We should bring it to the other body. We should get this passed. We should close this loophole, and we should protect New Hampshire children. That's what we should do. That's my long-winded answer.
Thank you, Representative. I believe that we have asked the representative. I think that we're going to move on from here. Thank you very much, Representative, for your presentation. Mr. Greenland, while you were out, we have some questions we were hoping that you could help us with. We have some questions around the sex offender registry and how long a person would be put on there. And our understanding is, it kind of goes with it whenever they're sentenced. Would you be able to get us some facts on the registry for sex offenders and send it out to the entire committee? Thank you very much. Ms. Graham?
Good afternoon, Madam Chair, members of the committee. Thank you for allowing me to speak to you today regarding HB 107 FN, relative to employment restrictions for registered sex offenders. My name is Jane Graham, and I am the Strategic Communications Administrator for the New Hampshire Department of Corrections. With me is Abby Simon. Abby is the Administrator of Sex Offender Treatment and Behavioral Health for the department. The Department of Corrections is neutral on HB 107. As the largest rehabilitation treatment provider for sexual offenders in the state of New Hampshire, the Department of Corrections supports legislation to safeguard individuals and families living in our community. We want to do all that we can to protect our children and keep them from falling victim to those who do them harm. While HB 107 has the greatest of intentions, we ask the committee to consider the use of more specific language in regard to providing direct services to minors or supervision or oversight of minors. As a department, our goal is to assist those who are incarcerated in their successful and safe reentry into the community. This includes transitioning individuals who have been convicted of sexual offenses. The broad language in HB 107 could have unintended consequence of restricting employment options for a group of people already at a disadvantage when entering the workforce. Many individuals enter fields of retail or food service upon their release from incarceration. Will this bill prevent them from working in industries that sell their products to minors or who serve food to minors? Will this prevent a sexual offender from becoming a shift supervisor at a fast food restaurant because they would be providing direct supervision to minors? The New Hampshire Department of Corrections agrees with the existing restrictions listed in current law and even go a step further to include others such as school bus driver or employment at a business whose primary intent is to deliver services to minors such as arcades, trampoline parks, etc. Employment is vital for successful reintegration into the community. These individuals need employment to afford treatment and engage in positive, healthy, and appropriate activities. By further restricting a person with a sexual offense's employment, it inadvertently increases risk factors through reduced employability, thus increasing the likelihood of reoffense. Stable employment provides the structure necessary to assist individuals with a successful transition and provides them with the income necessary to obtain housing and treatment to prevent homelessness. According to David Prescott, a researcher for the Association for the Treatment of Sexual Abusers, research has shown that offenders who are able to maintain stability in their homes and employment are less likely to commit further crimes. Public policy is therefore most effective when it considers those factors that prevent crime as well as those that make communities safer. In closing, I would like to reiterate the Department of Corrections' support for legislation that keeps our community safe and would urge the committee to consider the use of more specific language as they move forward. Thank you for this opportunity and for your time. I'm happy to answer any questions, and I brought Abby with me because she's the expert, so.
Thank you for your testimony. Are there any, Representative Bolden?
Thank you. Thanks for taking my question. I know that the grocery store we're not going to mention anymore, that is a pinnacle of this community, hires at 14. Is it currently legal for, to your knowledge, and I know that I'm the lawmaker, but is it currently legal for a business like that to put a convicted sex offender in a position of authority over someone who's 14, who's maybe a coworker?
I'm not a lawyer, but I can tell you that at a supermarket, they're not running a criminal background check. So if someone did become a supervisor, I would say yes, current law allows for that because you wouldn't even know, most likely.
Hold on one second. Representative Svitek?
You have obviously have prepared remarks. Do you mind emailing that to us?
Yes, and I have written copies as well that I'm happy to provide. I can give to the clerk.
Email's fine. but-
Okay, great.
Representative Muse?
Thank you for taking my question. When you say more specific language, it looks like the way that the law is written now is they actually make an attempt to identify specific situations. What the bill would do is actually generalize these situations in certain ways. Can you tell me why the DOC thinks it's important that we actually get insultingly specific with the conditions in this particular bill?
I do think so. Again, I referenced that a good portion of our responsibility is to make sure people safely transition back into communities. If we have language that's broad that prevents people from getting a stable job, that prevents us from safely rehabilitating folks and getting them into a stable environment so that they don't reoffend. I know, Abby, if you want to add, do you have anything to add, or you? Does that answer your question, Representative, or do you want me to get a little bit more specific?
Actually, if you could be more specific about
Okay.
things that actually, so for instance, the current law actually lays out some specific
It does.
situations where this is prohibited. Does the DOC think having some additional conditions that would actually potentially address some of Representative Vervil's concerns, does the DOC think it's worthwhile for us to look at adding things like that?
Absolutely. We would be supportive of looking at more specific examples of situations that you would not want a registered sex offender to be in. We just feel that this language is too broad.
Thank you.
Thank you.
I actually have a question. You had mentioned, the rehabilitation process and, people getting back to work and being members of society. My question is, will you give us an example of the percentage of sex offenders that re-offend or are re-offenders?
Do you know that? We don't have the statistics in front of us. I'd be happy to get that to you as soon as possible, so we can do that and send you information
Yeah,
after.
I actually would find that very helpful. Thank you. Are there any other questions from the committee? Seeing none, thank you very much.
Thank you.
Mr. Perot? I'm certain I slaughtered that.
Good afternoon. Sorry, I lost my voice. I'm Richard Peralta. I'm a detective sergeant with the New Hampshire State Police, and I am the commander of the Sex Offender Registry here in New Hampshire. Again, that's who I am. I'm here obviously today to provide some testimony into this. State Police is not taking a position for or against the proposed law. However, the language I think in the proposed law is vague and open to interpretation. For example, the definition of what a direct service is. That can mean a lot of different things, to a lot of different people, as we're all seeing in here today. There's also no definition of what a criminal background check is. In the proposed law, or a public or private employer, organization whose primary intent is to provide direct services to minors will conduct a criminal background check. Does that include a criminal record check? Or does it include, the employer calling his previous 3 jobs and finding out if he actually worked there? So those things I think are a little too vague. I understand this is, obviously by reading this, this is kind of an amendment to the law that already talks about providing direct services to minors. There are, to convolute this a little more, there are some offenses, sex offenses, that do not require registration. It's quite a convoluted system. So those things that are maybe will pop up in a background criminal record check, but that subject may not be on the sex offender registry. So if the employer goes to the sex offender registry to find out if this offender, if the subject or applicant is an offender, that obviously will not populate in the system. As far as fiscal impacts, I know I was supposed to talk about that briefly. I don't know what the fiscal impact, I don't have hard numbers on that. However, we at the Sex Offender Registry continue to get calls weekly, more daily, of employers who actually ask us, hey, we want to hire this guy. He's on the list. Can we hire them? So I would imagine in this case, if they're required to do criminal background checks, that's going to require either fingerprints or submission of criminal record check through the state. Those calls are going to, be more likely to happen more frequently than now. So again, state police is not taking a position either way, but I think the language in this should be cleaned up.
Thank you very much. Representative Newman?
Thank you for taking my question.
Yes, sir.
Are there different degrees of background checks? Is that why there is a problem with not having a legal definition of what a background check is?
Well, I think, if you ask me what a background check is, I've done, 15 or at least probably 10 to 15 background checks on new hires for us. A background check for me would be everything from getting his or her criminal record from the state, speaking with previous employers, speaking with neighbors, speaking with previous employers to see how he was as an employee. That's a background check to me. Background check to the owner of a small convenience store could be calling Walmart and Burger King and Target and the last 3 places that he or she worked. That could be his background check, and it may not pop up, or it may not indicate that he's a sex offender if he or she is not running a criminal background check through the state.
Thank you.
Sir.
Representative Selig?
Thank you. Thanks for your time and for taking my question.
Yes, ma'am.
You as well as the Department of Corrections both referenced using more specific language. Could I ask you what language you would find specific enough?
I don't know, ma'am. But I think where it says employment in businesses providing direct services to minors or direct supervision or oversight of minors, I think that's could be interpreted a lot of different ways. When I talked to some people earlier today and this week regarding this bill, the first thing that popped up was, well, wait a minute. My kid can't go to Dairy Queen and buy an ice cream? I said, well, I don't think that's the intent of the law, but that's the way he interpreted it when I asked him that. If you ask somebody that owns a landscape company, maybe they're going to have a different interpretation of that. So I think I really don't know how to word that better, but I think it's open to a lot of interpretation. Yes.
Representative Newell?
I'm just trying to parse out, and I think we are going to be getting a little bit more information around this, but I'm curious, you know, I mean, how would someone be on, you would do a criminal records check, right? Criminal background check.
Yes.
You would find an offense that is of a sexual nature.
Yes.
But what you're saying is it might come up in that, but they wouldn't be on the sex offender list. And so
Correct.
I'm really curious why that would happen, you know, why someone would not be on the.
So it is quite convoluted, but, you know, as an example, indecent exposure. Indecent exposure and lewdness, if the victim is not under 16, it is not registerable unless they do it twice in 5 years. So you could have a situation where, you know, you've got, well, I mean, it kind of outlines it there. You've got a situation where you've got a gentleman urinating you know, on the side of a building in front of a, you know, a 17-year-old. It's not registerable.
Right.
But if he does it again in 5 years, it's going to be. So he is convicted of that indecent exposure, but it's going to show up on his criminal record, but he's not on the registration. So there are, you know, a few examples of that. So the other part of that, to answer your question, if businesses that provide direct services to minors, and again, that's a broad statement, it's my belief that the certain sex acts, or the certain convictions of sexual acts, the ones that they have to register for possibly should be in that law as well, so that it's very clear cut. Because what's going to happen is you've got the manager of a small convenience store now having to do a criminal background check, and gets his criminal background check, but doesn't necessarily know how to interpret that and see, you know, well, you were convicted of this, so you're not going to have a job here. Well, I don't have to register. I'm not on the registry. Yeah, I urinated on a building, but I'm clearly not. Well, you're not going to get the job. So I think, and that's going to cause multiple, in my opinion, questions, calls to local jurisdictions, local PDs, my office, to clarify those things for different businesses. Does that make sense?
Yes, it does. I'd like to ask a follow-up if possible. Okay. I think in my reading of this, the onus is put on the individual, the person who has a record, or you know, so it, in the way that this is written, it doesn't clarify, to my knowledge, or you know, the way that I'm reading it, that it would be a responsibility of the business owner. It would be the responsibility of the individual who is trying to get a job or something like that, that they would be the person who is responsible for that in the end.
I see that. A person is guilty of a Class B felony, if been convicted, this jurisdiction in the paragraph, or he or she knowingly fails to provide that information. So I agree that the owner can only work with what he has for information.
Right.
So if that applicant leaves that off, however, now, if that applicant fills out that packet properly with his name, date of birth, all his information, and the owner of that business is required to do a criminal background check and does that, not only if that, you know, comes to light that he's now a sex offender, that applicant's going to be charged, I would imagine, for knowingly leaving that off, and he's not going to get the job. So,
Thank you.
Thank you for your testimony, Sergeant. Seeing no more pink cards, we will now close the public hearing for House
Madam
Bill
Chair.
107. What?
Madam Chair, could I ask Jean Graham to stick around after the hearing?
thank you.
We're going to be appointing, I know some people probably had some more questions. I'm going to appoint a subcommittee on this. So we'll be able to flesh out any more questions that you have. So on the subcommittee, it's going to be chaired by Representative Mannion, Representative Newell, Representative Muse, Representative Bolden, and Representative Peru. To add his experience to that. I didn't make you the chair. If you have questions, Representative Mannion, just ask me after. Okay, at this time, we're going to open the public hearing on HB 287. and call, is that, we got a pink card 287? For the next bill? None?
I'm going to say, do we have a sponsor here? It's Newell.
It should be Newell.
Yeah, she needs to know what she's doing. They said she knows everything, so that's the problem. Thank you, Chairman Roy. I will be introducing HB 287. I feel like there was a certain way I was supposed to say that, but it's my first time, so bear with me. My name is Jody Newell. I am representing Cheshire 4, which is a little slice of heaven over there in Keene. So the bill that I'm introducing today, removing testing equipment from the definition of drug paraphernalia in the Controlled Drug Act. That actually should be testing and analyzing equipment. I'm going to keep it very brief. It is a very, very brief piece of legislation. It's pretty quick. I think you probably would have read through it in about 2 minutes. So I will try not to take up a whole lot of time. So the idea of removing this from the definition of drug paraphernalia is that there is a little bit of confusion and vagueness around what is considered drug paraphernalia and then how that gets used, how people are responsible. I think we're all familiar with fentanyl test strips and things like that. That would fall under this heading. But it includes other ones like spectrometer and things like that. We all know that we have a substance use issue. The opiate overdose crisis is still raging in New Hampshire. Fortunately, in contrast to a lot of other states, our overdose deaths went down. I would like to call out the fact that it was the accessibility and the encouraged use of harm reduction tools that allowed that, because overdoses themselves did not go down. Overdose deaths went down. People were able to reduce those deaths because the availability of Narcan, a variety of different overdose harm reduction tools. Fentanyl test strips are something that we want to encourage people to use, right? We want people to be able to have this so that they do not die because there was something that was in their drugs that they did not know was there. Now, we don't really want to encourage use, but if someone is going to use, if we are dealing with reality, what we could do is we can reduce the harm on that person. Providing things like this provide for people to knowledgeably use substances, and it saves lives. It has been proven over and over. I have studies I can send you. To illustrate the idea of why this particular drug paraphernalia and the categorization of drug paraphernalia and what the implications are of having something like this as under that heading, I'd like to just share a short story. And like I said, I'm going to keep it brief. My boys and I were driving across the country. We did this a whole lot when they were little. It's probably 10 or 11 years ago. They were still toddlers. They were still in booster seats and car seats. We'll just say that. And we're driving across the country. We were going through Arkansas, and there's a lot of highway traffic. And so I said, oh, I'm just going to take this alternate route. We get off on this alternate route. And unfortunately, apparently, I was still driving like I was on the highway. So I got pulled over. I was speeding, going about 10 miles above the speed limit. Well, the officer pulls me over, and it's a veteran, and he's training a rookie. And he comes over to my window, and he's kind of, the passenger side window, and is kind of leaning over and talking to me through that window. We're talking about speeding and where am I coming from. I had Massachusetts place at the time, and here I am in Arkansas. And he mentions to me, he says, what is that smell? I said, well, I'm not sure what that smell is because I'm driving in a car with my toddlers. So I don't smoke in my car, but I do smoke. He says, well, what brand of cigarettes do you smoke? I said, oh, well, there's not really a brand. I roll my own, and he's very curious about that. And I said, here I have my setup because, when I take a break and want to get out of the car, I have my whole setup over here to roll up a cigarette, right? So I have a box of tubes, I have a big bag of tobacco, and then I have this crank machine where you just kind of put the tube with the filter on the end of it, you put the tobacco in, boom, you crank it, wonderful. Great little machine, handy dandy. Well, he did not know what that was. And even though I was explaining to him and I had the entire setup there, he decided that that was drug paraphernalia, a tobacco rolling setup. So because he decided that, that allowed him to be able to search my car, get my children and I out of the car, ask me to get out, pull out the car seats, the booster seat, all that kind of stuff. I'm sitting on the side of basically some random route in Arkansas, humiliated out of my mind for about 30 to 45 minutes because this officer decided that this was drug paraphernalia. And because of that, he was able to steal my property. He took my property, my rolling machine, which is wonderful because I have that because I'm broke and it saves you money. But okay. Takes my property. He pulls everything out of my car. We're on a 6 to 8 week road trip. Do you want to know how much stuff was in my car? There was a lot. Pulls out the booster seats, all this kind of stuff. Me and my toddler children on the side of the road. Of course, he's going through everything and he's thinking that, you know, every little cigar box is going to be hit the jackpot. Oh, we're going to find the weed. We're going to find something. No, he found nothing. There was nothing in my car. Because he considered this drug paraphernalia, it allowed him to take possession of my property. It allowed him to negate my civil liberties and search my car, and it allowed him to humiliate me on the side of the road. This is a minor story. So, and at the end of the day, I have a charge for drug paraphernalia possession because he decided that that was drug paraphernalia. So the importance of identifying what is and what isn't drug paraphernalia, I find very important for our civil liberties and to be able to save lives in this situation as far as we're talking about the overdose crisis. I'm going to wrap it up there. I do have the RSA that this is included in. I'll pass it around. I have copies for everyone so that you can see where this fits into the Controlled Drug Act. And yeah, open any questions.
Representative Newman.
Could you just give a brief description about what the test strips are like and how they're used or cumbersome or that whole situation to the degree that you think is necessary to clarify that?
Yeah, they're pretty much, I mean, picture a pregnancy test. It's very similar to that.
There being no further questions, thank you very much.
Thank you.
The chair calls Anina Hansen? Anina.
Good afternoon, members of the committee. Thanks for having me here. I paused a second there because Representative Newman, I believe you asked about test strips. I have some right here. It's in a little packet. It's used for urinalysis to test if somebody has, you know, it'll show up in your urine, what drugs you're using, if you have the right panels to test for it. But you can use it to test your drugs by taking a little bit of the powder and mixing it with some water, and you dip it in the same way. So that's how they are used. So it's a medical tool, basically. It is a urinalysis device that is used in a medical setting in that way, but can also be used to see if fentanyl pings on there. Does that help?
Mr. Chair, can I say thank you for that clarification? Because
You may
I
indeed.
was absolutely confused.
Okay. If you would like to know more, you know, I can leave them here for visual aid for anybody who would like them. But let us move forward. Thank you so much, everybody. My name is Anina Hansen. I'm a resident of Peterborough. I'm a person in recovery from alcoholism, and I support HB 287 because it eliminates the possibility that anyone could face legal charges for possession of a medical tool that helps to keep people alive. There's someone else who would have loved to be here today testifying in favor of this bill, and that's my life partner, Phil Spaniolo. Phil was a New Hampshire state rep for Belknap County, who sat on the Health and Human Services Committee, and he was in long-term recovery from alcohol and heroin addiction. My guy was fearless about sharing his story of substance addiction, right up until he wasn't, until his mental health issues, untreated during COVID, got the better of him, and he relapsed, and a year and a half ago, died in a Manchester drug den of a fentanyl overdose. If I could go back, I would do anything to get some fentanyl test strips in his hands. I would say, honey, while we figure out how to get you the help you need, let's keep you safe. I know it seems counterintuitive to help people use illegal drugs safely. I thought so too. Last March, 8 months after Phil's death, I took a job at a recovery community organization, and that's where I first encountered fentanyl test strips. Me, a woman who lost the man I thought I would grow old with due to fentanyl poisoning, I'm supposed to help people see if their drugs have fentanyl so they can keep using. But as I learned more, I realized it actually makes sense. The basic science of substance addiction teaches that once someone is chemically addicted to a drug, the physiology of the brain changes. Because drugs mirror the pain-ending, pleasure-inducing chemical response of natural life-sustaining processes such as eating, the brain can come to associate drugs with survival in the same way. In addition to having served as a state rep, Phil worked in recovery, he owned 2 sober houses. There was no one better educated than he on the dangers of street drugs. So why did he use? Because his brain had been hijacked, reprogrammed to demand that he pick up heroin in order to live, the same way your brain would demand you surface to breathe after being underwater too long. Logic leaves. This is survival. Of course, the brain can be reminded, oh, right, I can stay alive without this drug. Millions of people have recovered from substance addiction. I'm 6 years sober, and I'm living my best life. But you know who cannot recover from substance addiction? Dead people. Dead people have a 0% recovery success rate, and that is why I have fallen in love with fentanyl test strips, because each one represents a second chance. A precious person, someone's beloved, getting another chance to live their best life someday too. New Hampshire's drug overdose rates are 54% higher than the national average. Addressing our state's drug problem is a big issue, and it shouldn't get bogged down in tiny distractions. It's a crime to use drugs such as heroin, cocaine, or meth, all of which are now routinely contaminated with fentanyl in potentially lethal amounts. But it should not be a crime to try and stay alive long enough to stop using them. I just learned a few days ago when Representative Newell asked me to testify today that fentanyl test strips are legally classified as drug paraphernalia. And let me tell you, that was a real shock, because now in my professional capacity, I carry them around in my car by the boxful. You mean to tell me I could be charged with possessing drug paraphernalia? Oh, get out of here. What a distraction. Diverting our valuable law enforcement resources away from the problem and the solution, sidetracked by a technicality while our actual drug problems continue unchecked. And they are big. Like, I am not minimizing that in any way. And I so appreciate the effort that law enforcement makes and the uphill battle they are fighting. And I just think this is a distracting issue. If my guy was alive, he'd be here today testifying in favor of this bill. And the irony is that if he had had fentanyl test strips, he could be alive. Giving people who use drugs materials to test their drugs is not about promoting drug use or illegal behavior. It's about keeping humans who are in trouble alive until they can get help, period. And let's never forget that the problem isn't just out there. Sometimes the people who would benefit from fentanyl test strips are sitting right here in these chairs, or have loved ones, people that are close to you who might be struggling with this too. So I'm asking for Phil and for me and for all the people with hijacked brains and for all the people who love them, please support HB 287 and remove the possibility that anyone could face criminal charges for possession of test strips, so that we can keep our focus on the real problems around drug use and help our citizens live to tell their recovery stories. Thank you. Open to questions, if there's anything.
No questions. Thank you very much for your testimony.
Thank you.
This time the chair will call Daniel Colpobia.
Thank you very much, Mr. Chair and members of the committee. I'm Representative Popovich Mueller. I'm a freshman from Windham, and I really appreciate your time. I know how busy you are, so I'm going to keep this as short as I can and try not to repeat anything that you already know, like, for example, the fact that drug use is deadly, even when the drugs are pure, but contaminated drugs are deadlier. And I think it behooves us to do whatever we can to decrease that damage. At the end of the day, harm reduction is the right way to look at the drug policy. Right now, the law is written, includes those two words that this bill is trying to remove, that include the testing and analyzing equipment in drug paraphernalia, therefore providing an incentive for people not to have them, which leads to worse outcomes. And I believe that the words were included at the time when the bill was written because at the time everybody thought that only drug dealers would need those things. We are in a different world today where those types of devices, medical devices, are available widely, and we need to reconsider the impact of that policy. Removing the testing and analyzing equipment would allow us to still prosecute drug dealers. Look at the remaining drug paraphernalia definitions. It's extensive. There is no drug dealer that's just going to have testing and analyzing equipment. It would not in any way decrease the ability of our justice system to prosecute and, put the drug dealers where they belong. But it would allow people who just have the testing equipment, whether it's for themselves or, people like we just heard, people who just try to help others and provide services to people in need, not worry about, being criminally prosecuted for allowing to help. The law as written just removes the definition of those two words, removes it from the law. But frankly, one could argue, and this is not the intent of this law, that drug dealers who have testing and equipment should receive a more favorable outcome because they are trying to, do less harm. But again, that's beyond the scope of this law. I want to also remind everybody that banning those devices by making their possession illegal is providing a disincentive to people who research and produce those devices. If you know that you cannot sell them in the state of New Hampshire, at least not legally, less money will be invested in life-saving technologies and drugs. So to sum up, from the point of view of criminal justice, this bill does not in any way decrease the ability to prosecute drug dealers. From the point of view of public safety, it will have a clear positive impact by helping people help themselves or help others. And since I didn't know at the time when I co-sponsored the bill that I'm going to end up on the finance committee, but that's where I ended up, I can assure you that any revenues that the state misses are going to be tiny, and the expenditures of prosecuting people in these situations are going to greatly, basically it's going to have a positive financial impact too, even though frankly that shouldn't really be your consideration. But since it has an FN designation, that's something that I wanted to bring up. I really appreciate your time, and I'm available for any questions. Thank you.
Thank you for your testimony.
Thank you.
The chair calls Carrie Nolte.
Thank you so much to the committee. I am Carrie Nolte. I'm an associate professor of nursing at the University of New Hampshire, where my research focuses on harm reduction and reducing drug-related harms like infection and overdose. I'm also a family nurse practitioner who practices in healthcare for the homeless through van-based outreach. And I'm here speaking on behalf of myself, although with my expertise as my background. I have submitted written testimony by email to the committee, including quite a few links and education around drug checking and the evidence for it. And I just want to speak out in support of House Bill 287. As you know, there is currently some question as to whether fentanyl test strips could be prosecuted. But I would also like to share a little bit about comprehensive drug checking. So and call the committee's attention to House Bill 470, which is also has been referred to your committee and hopefully will be heard at a later date. So fentanyl test strips are very important in order to check the presence of one substance, fentanyl. We anticipate there also will be more rapid tests available for other substances that are being cut into the drug supply. But in the meantime, a best practice around comprehensive drug checking has been developed, and in my opinion, House Bill 470 more comprehensively allows this. And so within comprehensive drug checking, these are usually using what are called FTIR machines. Don't ask me the abbreviation, in order to get the specific substances. One substance we're seeing in clinical care, or we think we're seeing in clinical care, but we can't quantify it because we don't have comprehensive drug checking, is something called xylazine. Xylazine is an animal tranquilizer. It's used in veterinary medicine, and we perceive that based on it being identified in local states, Massachusetts and Rhode Island, with similar presentations, it's present in New Hampshire. It can cause different sedating side effects than opiates. It can cause a decrease in heart rate, but probably the most prominent thing we're seeing clinically is really, really severe wounds that are more like, are infected, but are also more consistent with burns. There's almost like a chemical burn component to using this. So as substances will be ever changing and the drug supply will become more and more dangerous, I think you see the importance based on 2 bills being brought to the House in this session on drug checking. And although I support House Bill 287, I think that the committee could take a deeper dive into 470 and consider that as a best practice which has been used across other states. One of the concerns around, so House Bill 287 will eliminate testing and analyzing, and that is important for rapid test strips like fentanyl test strips. But comprehensive drug checking does go beyond that. There will be processing and preparing and packaging, and so those are some of the things, and I won't go into all of the details, but will be coming to the committee to look at, and I'm happy to answer questions.
Thank you for your testimony. Representative Newman, did you have a question?
I just had a quick question about 470. Is it more, you said it was more comprehensive than this. Does it remove drug
Yeah,
paraphernalia from-
Representative Newman, that's coming, so we'll address that when it comes. Thank you. Kate Fay.
Good afternoon. I'm sorry for my handwriting. It's actually Kate Fry. I'm the Vice President
no,
of
it's me.
Advocacy.
I'm blind.
I'm sure it was my handwriting. I'll be very brief. We do support New Future. I'm the Vice President of Advocacy at New Futures. We support evidence-based prevention, treatment, and recovery policies for health and wellness and substance use disorder. We are in support of House Bill 287. We stand with our colleagues who have said it'd be great for the committee to also take a deeper dive into HB 470 since that's more comprehensive. So I won't go into long testimony today, but I will leave you with both a CDC overview of fentanyl test strips, why they are effective harm reduction strategy, as well as a more detailed article from Health Affairs outlining why these strips empower people and save lives. And so hopefully that will provide you with background information as well.
Thank you for your testimony. Representative Muse.
Representative.
One of the things I know that your organization is very selective with when it comes to supporting things like legalization, this isn't something that you do lightly, as we'll probably find out during the cannabis hearings. Um, but can you talk a little bit about a harm reduction strategy and where your organization is on that, and how and what you think of that as an overall way for sort of lessening the impact of the issues we're seeing with fentanyl and other opioids now?
So we are absolutely supportive of the full continuum of care with substance use disorder. That means prevention, primary, secondary, tertiary treatment, and recovery. Harm reduction is a key piece of the puzzle. And so fentanyl test strips, along with Narcan and the Good Samaritan Law, all bills we supported and actually helped write. We are very behind harm reduction strategies. When we get into the cannabis discussion, I think the issues we have has been around a lack of principles around protecting children in previous versions of the law. We want to be careful about not advertising and marketing to them. We want to be careful about making sure we have potency limits, just like we do with alcohol. So those are basic prevention, primary prevention, but we also support tertiary and secondary prevention steps, of which fentanyl test strips are one.
Thank you for your testimony.
Thank you.
The chair calls Frank Knack from the ACLU.
Mr. Chairman, members of the committee, thank you so much for the opportunity to testify today. My name is Frank Knack. I'm the policy director with the ACLU of New Hampshire, and we are here in strong support of HB 287. This really provides New Hampshire, as you've heard, with an opportunity to build on its harm reduction successes. You know, when naloxone was introduced back in 2015, by 2017, we had seen the current peak in overdose deaths at 490. And we had, more recently, the New Hampshire Drug Monitoring Initiative, which is part of the Department of Health and Human Services, quotes state that naloxone very likely contributed to both a decline in overdose deaths and EMS-provided Narcan administration through 2019. And then if you look at just November 21 through October 22, that 1 year period, the administration of naloxone by EMS saved 865 lives. And so the embrace of harm reduction strategies by New Hampshire is having a huge positive impact at saving lives. And this legislation is the next step in ensuring that we have a harm reduction, a number of harm reduction tools that continue to save lives. And so I want to touch on two myths around fentanyl test strips that may come up, haven't so far. One is that they're used to test the purity of the substance, and that's just not true. It's like a COVID test strip. It just tests whether the substance is in there or not. And so the notion that, people are using it to test the drug purity is just not true. That's not how they function. And the second is that they encourage drug use. And for this, I want to just quote the director of the Office of National Drug Control Policy, who said, quote, "There is no scientific evidence to support this notion that harm reduction services like fentanyl test strips somehow encourage drug use, but there is significant evidence to support the fact that these tools can save lives." And so this is coming from the head of the Office of National Drug Control Policies. In addition, you have major governmental, non-governmental, medical, and public health organizations all stating that we should have these harm reduction tools available, including the CDC, the Substance Abuse and Mental Health Services Administration, and the American Medical Association. And finally, 24 states have legalized both the possession and distribution of fentanyl test strips, including our neighbors in Vermont, Maine, and Massachusetts. And in just the period between August 1, 2021 and August 31, 2022, so just that 13-month recent period, we saw 10 states move in this direction, including deep red states like Alabama, Tennessee, and Louisiana. And so this is, again, another harm reduction option that we have that we should embrace, and happy to answer any questions.
Representative Bolden.
Thank you, Mr. Chair. Thank you for taking my question. Is there any evidence that the use of a fentanyl test strip might discourage drug use in that it may identify an unwanted substance that wasn't what someone thought they were purchasing?
But what I can say is there is significant evidence through peer-reviewed studies that show that when people use fentanyl test strips, that there's a much greater likelihood that they will ensure that they're using with someone else who could call 911 or administer Narcan. If they have an overdose, that they'll use less of the drug if it tests positive for fentanyl. And so again, these are documented findings that show that these are a significant harm reduction tool that should be available.
Thank you for your testimony.
Thank you.
At this time, the chair calls Representative Christine Siebert.
Hi, thank you for hearing me today. My name is Christine Seibert. I'm from Ward 1 in Manchester, District 21. And I'll make this brief because a lot of people already hit on a lot of the points and they did a great job. But I just wanted to bring up, they are a harm reduction tool. The big one I want to mention is they do not assist in the use of drugs. So they are not used as a tool within the drug use itself. And we obviously have a really big problem in Manchester. Our services are overwhelmed. Our response, the EMS, fire, everyone. They also have to send everyone out when anything happens. There's also people that overdose multiple times. And this also, contributes to the fatigue that you hear many first responders speak of. And so and when I was canvassing for running for office this past summer, this was something a lot of people brought up. So this would be, and a lot of it is about the money and the services that a lot of this costs. So I just believe overall, this is a great tool. And I understand maybe someone originally did this with some hopefully good intentions, but the problems become overwhelming, and it's become overwhelming across the entire country. So I hope you will vote in support of this bill. Thank you so much.
Thank you very much. This time, the chair calls Lauren McKinley.
Hi, my name is Lauren McGinley. I am the Executive Director of the New Hampshire Harm Reduction Coalition. I wanted to take just a few moments to say, I'll go so far as to say that New Hampshire Harm Reduction Coalition is probably the state's largest distributor of fentanyl test strips. We've been utilizing them since April of 2021 when the CDC and SAMHSA issued a co-request to funded entities to begin using them to prevent fatal overdoses due to fentanyl contamination in all substances. So it's important to think when we think fentanyl, we generally think a contaminant in heroin. Fentanyl can be a contaminant and is currently being seen as a contaminant in a lot of substances that people are not familiar with the presence of fentanyl or in how to react to a potential fentanyl or opioid-induced overdose. So if you casually use, say, cocaine on the weekends, as many college students typically will start to experiment with, you would not have the proper tools on hand to address an opioid-induced overdose because cocaine users, stimulant users, are not typically aware of how to react to an overdose like that. So fentanyl test strips serve a really important tool with people who use drugs to identify not only what is in their drug supply, so the presence of fentanyl is a yes or no that these fentanyl test strips can provide, nothing further than that, but also where fentanyl is starting to be seen, including in stimulants like cocaine and methamphetamines. As the largest distributor of fentanyl test strips, I just want to call to the committee's attention that federal resources are completely able to be applied to the purchase of fentanyl test strips and have been able to been utilized since April of 2021. We have an incredibly large surplus of fentanyl test strips and have made the offer to supply them to whichever organization feels like they would benefit from having them. Additionally, I would be happy to answer any questions if people have questions relative to how a person who uses drugs utilizes fentanyl test strips, or what some of the anecdotal responses have been having them as a supply at our harm reduction events. That's it.
I have a question. Are people able to just, do you have a location where people are able to come in and obtain these?
Yes, yep, absolutely. So we make ourselves present in many different ways. And we've had people reach out to us via social media. We've had people show up at some of our harm reduction events or syringe service programs. We also have the ability to connect them to a regional care coordinator who can help them procure the test strips, but then also review with them quickly how to use it appropriately to interpret the results.
And if this bill were passed and to become law, do you have the infrastructure to get these out into the community in a broader way quickly?
Yes, absolutely. And we already have practice with that. We are currently a covered entity that is allowed to distribute fentanyl test strips because they are included in the SSP law in the state of New Hampshire as any tools that are used to prevent overdoses.
Representative Bolden.
Thank you. Your testimony.
Sure.
You're saying that the distribution of fentanyl test strips is currently federally funded, and that also under current law, someone who obtains that through federal funds could be charged with possession of paraphernalia?
Great question, and it is slightly confusing. So the list of entities in the state of New Hampshire that can safely distribute fentanyl test strips is very small. I know that my organization is protected under the SSP law in the state of New Hampshire because I can distribute a list of supplies, syringes, safe injection equipment, Narcan, naloxone, and any other device that may prevent harms occurring from the use of substances. There are many places that are not protected, but are able to distribute them if they feel like the legal risk is.
To be clear, though, whoever you give it to would be in violation once they possess it?
I don't believe so, actually. I think that the onus is on the distributing entity, and once they are received by individuals, there is not a legal risk there. I am not a lawyer, though. There is one here.
Okay. Representative Bolden, do you have a follow-up? Oh, I'm sorry. I didn't mean to steal that.
So to be clear, if I go to the new shelter on Maple Street in Manchester, where they have test strips available, and I take some and I have them on me and I'm stopped, could I be charged with possession? And similarly, if I were to say give one to the guy that camps at the Hanford by my house, like I did recently, could he be charged with possession of paraphernalia?
This is a great question, and one that we've been struggling with in the state since Samson, the CDC, requested that programs start distributing them in this way. And I don't have a great answer for you. I'm sorry. I think it kind of highlights the need for the clarification of language like this, because I think it was said best. It is such a distracting technicality to be held up on when such important work can be done with the utilization of this and many other tools.
Thank you for your testimony.
Thank you.
Is there anyone else who wishes to testify about this who has not handed in a pink card until the last second? No, unless you're an attorney, I'd rather not.
Thank you, Mr. Chair. Oh, did you call me officially?
The honorable representative. Date to see. Reem.
Thank you, Mr. Chair.
I
and
didn't
thank-
get your card yet, so.
There it is. And thank you, honorable members of the committee. For the record, my name is Ellen Reed, and I represent Newmarket and Newfields. And I hesitated to put my card in because I don't think there's too much that I can add, but there were a couple small things that I thought I could add. First, I want to clarify the answer that I just received. It's the members of those organizations that may have some legal protection. So if you have joined one of those organizations and you're officially a member, then you might have in court after a police officer has charged you with paraphernalia and you go through that process, you might have some legal protection there. However, so I cannot speak as other people have as a person who uses any drugs. I actually developed an intolerance to marijuana when I was in my 20s, and I have a commercial driver's license. So I don't have a dog in the race in that sense, and I'm not an expert like the other people, but I am a lawmaker, as you all are. And I can say, in my opinion, as a lawmaker, this should have never been put into this law. The ridiculousness of the idea of testing and analyzing equipment being put into the paraphernalia law, I think, is made clear by the fact that you just witnessed a crime from an earlier speaker who showed you paraphernalia. I don't think anybody in this room thinks that she should be arrested. I think that these words were put into law in a punitive sense. At a time where it was more common, although we haven't gotten rid of stigma, it was more common to think of drug users in a stigmatized way, that they have an inherent moral failing instead of the way that we now understand them to have a health condition. And we know that we cannot penalize people out of mental health or substance abuse conditions. I think we all know unquestionably that the state and the country are tending towards legalization of different substances anyway. But I think if the original purpose of these laws was originally to help people not use drugs, then we should not, in fact, be punishing people who are just trying to survive their condition. And the last thing I'll say as a lawmaker, since I know that you have another bill that's similar but more complicated, one path forward may be to pass this so that you have at least something through the simpler thing and retain the other more complex bill. You'll probably want to get into more detail over the fall, and then you have either a second bite at the apple or another piece of legislation if you want to get into more details. But that is my opinion as a lawmaker. Thank you very much for your time. I can't imagine anybody has questions, but I'm here for them.
Representative Wheeler.
Thank you, Representative Reed, for taking my question, and thank you, Mr. Chairman, for letting me ask it. My question was for Representative Newell, but I'm wondering if you'd be able to answer it, seeing as though you had your last sentence there. There is HB 470 on the docket here, and I'm just wondering why this legislation came.
Representative, I don't mean to interrupt you, but are you a co-sponsor on this bill?
Am I not allowed?
No, you're not. We're not allowed
My
to.
apologies, I didn't know.
That's why I sat on my hands for the last bill, but she heard it, so if she wants to go ahead and answer, that's okay.
I think the new House rule that I helped get through is that everyone is entitled to either participate from one or the other side, regardless of condition of co-sponsorship. However, having said that, yes, I would say that I think a prudent way forward to make sure that this committee has the ability to pass this either this concept either this year or next year, depending on whether or not the Senate goes for this year's version, is to pass one and retain one. And since the other one that you have before you is the more complex one, it makes sense that that's the one retained. This is very simple, elegant language, I think, just strikes two words. And I think it makes sense to go ahead and get it in the Senate's hands sooner rather than later.
Thank you. At this time, I'm going to ask, there's a captain here from the state police, if he could come up and just elucidate a little bit on the legality of possession currently as the law states.
Thank you, Chairman. Yes, just so to kind of address the overall question, I guess by the technicality of it, could somebody technically be in violation of possessing drug paraphernalia? It seems like that probably could be, but I am not aware of any current cases like this. in that situation where, fentanyl test strips have been charged as drug paraphernalia or anything like that. I do understand that the intention of the bill is to, support the harm reduction, tools that we already have in place. As from the state police perspective, I wasn't going to take a position on this bill one way or another. My intention was to monitor it to see if there were potentially any unintended consequences with taking that language out. At the moment, I don't see any, but I'm also not an attorney. I'm not well versed in, in a lot of the legal aspects of these things. But by the letter of the law, somebody could potentially be charged. But like I say, I'm not aware of any cases of that happening at the moment.
So just to put a fine point on it, currently there is legal liability exposure, regardless of whether or not it's being charged. It's still out there.
In my opinion, I think that there could be, but I also was not aware of the people that are distributing it, so that is new to me. And their protections that they have with it coming from federal funding and things like that. I was not aware of that, but I also, I'm not aware of any cases where this has been an issue.
Thank you. Does anyone have any questions? Go ahead.
So also to put a finer point, thank you, by the way, thanks for taking my question. You're saying that you don't see any, and I know that you're speaking sort of casually because you haven't had a ton of time to prepare, but you're saying that you don't see any potential negative consequences of basically passing this bill as written?
I mean, I read the bill as it's written, trying to think outside the box to see if there were potentially any unintended consequences from what the bill's intention was. At the moment, I personally don't see any, but I'll just leave it at that if I can. Yeah.
Thank you very much for stepping up. You wanted to say something?
Yeah, I just wanted to clarify the section that criminalizes currently. That'd be helpful.
Yeah, sure. Just go ahead and read it so everyone can take it down if you want to take a note.
Again, Frank Kinnock, ACLU of New Hampshire. So under RSA 318B26(3), it says a person shall be guilty of a misdemeanor who ... delivers, possesses with the intent to deliver any drug paraphernalia. And so under the definition of drug paraphernalia in New Hampshire, testing falls under that. So it's an unclassified misdemeanor to distribute. So it'd be like the Harm Reduction Coalition is protected, but if I gave it to someone else who would benefit from it, I would be liable.
Is it your understanding that anyone they give it to is protected, or only they as a distributor are protected?
So under the current law, possession is protected, but if someone gives it to someone else, that's distribution, not protected.
Very good. Thank you very much.
Thank
I
you.
appreciate it. Is there anyone else wishing to testify who has not already testified? There being none, I will go ahead and close the public hearing. That concludes our business for today. If anyone has any questions, please come up and see me afterwards. Please make note of your subcommittee assignment, and I will see you all tomorrow.